All rise. Oh yay, oh yay, oh yay. This Honorable Court of Appeals of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court. Please be seated.
You turn the microphones on?
Yes, sir.
I have to mess with Mr. Hibner a little bit. Good morning and welcome to the Court of Appeals. First, I want to tell you how much we appreciate the opportunity to be here and to hold court in this beautiful facility. We appreciate Professor Vescovo and all her efforts that she makes to pull this off. And I tell you, there's a whole lot more that goes on behind the scene than anybody knows about. And she works hard to do that. And we very much appreciate that. I think Mr. Hibner has explained the process. Just a moment, we're going to call a case. We're going to hear the oral arguments from the parties. Then the court will retire and discuss the case. Obviously, we will not make a decision today, but we will prepare a written opinion and we will furnish that to Professor Vescovo. So if anybody's interested in it, you can certainly read that. That'll hopefully be in the next 60 days, but we won't orally rule here today. After we have retired, though, I'm assuming the lawyers will be happy to talk to you about the process and why they did what they did or why they didn't do what you thought they may have should have done. So I know that that's always enlightening for law students. I think that's pretty much it, isn't it, Mr. Hibner? Okay. Let me explain our process as we go through this oral argument. It's a fairly simple process. When we start, the appellant will be given 15 minutes to make its oral argument. The appellant may reserve up to 5 minutes of rebuttal time, which means the appellant can come back after the appellee has made its argument and present any rebuttal that it may wish. Appellee gets no rebuttal time. We have a series of lights on the podium. When the argument starts, a green light comes on. That means you've got plenty of time. When your time nears the end, a yellow light comes on, simply warning you that you need to begin to wind up your oral argument. And finally, a red light will come on when your time has expired. We asked, of course, and for law students' benefit as well, you need to respect those time constraints. Different courts look at it different ways. Obviously, we're going to let you finish what you've got to say, but some courts don't look at it that way. As far as requesting oral argument by the appellant, the proper way to do that from this court's perspective is after you've come up and introduced yourself. But before you begin your oral argument, you request that time from the court, not from the clerk. Clerk can't grant you oral any rebuttal time. The court can. So be sure to address the court in requesting rebuttal time. One other thing, are we live streaming this? Okay. Very important. These arguments are being live streamed. What that means for the attorneys who are making the arguments is for you to think about what you're saying, because once you've said it, it's out there for everybody to hear, and we can't take it back and can't do anything about it. For the law students, if you want to go back and watch these oral arguments for any reason, they'll be available on the Tennessee Court YouTube page, I believe. Is that right? Mr. Hibner can give you that address if you need it. Anything else we need to take up before we call the first case? Your panel this morning consists of Judge Karma McGee from Savannah, Judge Valerie Smith from Memphis, and I'm Steve Stafford from Dyersburg. Ms. Tibner, you may call the first case, please.
Scott Patrick Werner et al. Versus DeAnthony Melton.
And we will hear from the appellant.
Judge Stafford, Judge McGee, Judge Smith, good to see you again. Good morning. May it please the court. My name is Aubrey Greer of the law firm of Glenkler Brown here in Memphis. I, along with my co-counsel, Mr. S.T. Rayburn, and my partner, Larry Montgomery, represent the defendant appellant DeAnthony Melton in the case that's before the court today. Your Honor, at this time, I would like to reserve 4 minutes for rebuttal. Four, please.
All right. You may proceed.
The case before the court today is one arising from negligence. It's a case that arises from a dog bite. The plaintiff, Dr. Werner, filed a complaint in which he alleged that my client, Mr. Melton's dog, escaped Mr. Melton's property, entered upon his, that is, Dr. Werner's property, and viciously and savagely attacked him. Dr. Werner ultimately obtained a judgment for a little more than $750,000, even though the complaint filed in the case had an ad damnum requesting only up to $250,000. Mr. Melton subsequently moved to set aside the judgment under Rule 60.02, and while the court initially granted the motion, Judge Hurd ultimately reversed herself and denied the motion. On appeal, Mr. Melton asked this court to reverse Judge Hurd's denial of that motion for 3 primary reasons. The first, Mr. Melton was not properly served with process in the case, which renders the entire judgment void. Second, the amount of the judgment is triple the ad damnum that's in the complaint and 13 times the economic damages sought in the case. Case law is clear in the state of Tennessee that damages awards that are in excess of the ad damnum, the amount prayed for in the complaint, are void as to the excess. So Mr. Melton maintains that any amount over $250, if the court were allowed the judgment to stand, is void. Third, the judgment was procured based on a false or misleading set of facts and therefore should be set aside, and Judge Hurd's ruling should be reversed. As such...
Let me pose a question to
Yes, Your Honor.
Just initially. Seems to me that the crux of the argument is that the trial court erred in not granting your motion for relief under Rule 60. Would that be accurate?
I agree, Your Honor.
The trial court also, though, said that your motion was late, did it not?
Timeliness, whether or not the motion was filed within a reasonable period of time, that was part of Judge Hurd's ruling. You are correct, Your Honor.
Was that appealed?
The timeliness aspect, the entirety of Judge Hurd's motion was appealed. Yes, Your Honor.
Was that specifically listed as an issue on appeal?
I don't know if it was listed in the statement of the issues, but the reasonableness of the time period was certainly discussed in the briefing, Your Honor.
I understand that, but I'm trying to ascertain if it in fact was listed as an issue.
I don't believe the reasonableness in terms of the time period was specifically called out in the list of issues in the initial brief, or in the note, or I guess in the notice of appeal as well, Your Honor.
Okay. And what's the standard for us reviewing the trial court's decision on a Rule 60 motion?
Your Honor, the standard of review is two-part. Generally, rulings under Rule 60.02 are reviewed for abuse of discretion. Obviously, if there are questions that go to questions of law, that's a de novo review by this court. So contested issues of fact, decisions regarding contested issues of fact, abuse of discretion, legal issues, like whether or not there was personal jurisdiction, voidness of judgments, that's a de novo review.
Understand, but I guess for me, the initial question is, trial court said it's a timeliness issue, and we don't ever get to the substantive arguments if, in fact, we don't get past what the trial court said on timeliness, correct?
The timeliness aspect actually comes into play in a couple different ways, Your Honor. So as to judgments that are void, this court, and in fact, I think Your Honor actually wrote an opinion about 11 years ago that recites that the standing precedent in the state of Tennessee is that Judgments that are void, that are challenged for voidness, the time limitation, that reasonable time limitation, even that 1-year time limitation that appears in Rule 60, does not apply to challenging void judgments. So as to the voidness issues, the timeliness, the reasonableness of the timeliness matter does not matter for the purpose of this court.
Why would it be void?
Absence of service of process, Your Honor. Service of process is what gets the defendant into the case and allows the court to bind the defendant to the decision. Absent proper service of process, the defendant's not in the case, and anything that happens has no force or effect legally.
But you can waive service of process, can't you?
Absolutely, Your Honor. You can certainly waive service of process.
So, I'm trying to recall specifically what the trial court said, and that's another question I have for you when we get there, is which service of process actually was valid in this case. But I don't know that failure of service of process necessarily makes this a void judgment. I understand your argument, but I don't know that it actually would come out that way.
Your Honor, I think the case law in Tennessee is relatively clear, as I said a moment ago. If the defendant is not properly served and brought into the case, the things that happen after that, the court doesn't have the power to bind the defendant to that. If the court doesn't have the power to adjudicate the issue and bind the defendant, how could the judgment possibly stand? It has to be void. And I think that's what the case law says, Your Honor.
But that's not what the trial court ruled.
Well, the trial court based its ruling, so Your Honor asked a question a moment ago about which service of process, because you're right, there were a lot of attempts at service of process. There were mailings, there was service by publication. Really, the two instances that I think this case comes down to, and I think Mr. Culpepper will probably agree with me, is there was a March 29th, 2023 attempt by a Pennsylvania process server. He was retained, I believe, by Mr. Culpepper to go out to a house in New Jersey where Mr. Melton was believed to be residing while he was playing with the Philadelphia 76ers at that time. At the time Mr. Culpepper had filed his complaint, Mr. Melton was playing for the Memphis Grizzlies. He was subsequently traded to the Sixers, and that's why there was a difficulty in effecting service here in the state of Tennessee. So once there was this thought that Mr. Melton lives at this house in New Jersey, a Pennsylvania process server went out to the home, knocked on the door. A gentleman answered. That gentleman's name is Stephen Ushery. He is Mr. Melton's uncle. Mr. Melton was not home. He was not at the address at that time. Mr. Melton was actually in downtown Philadelphia playing a game against the Dallas Mavericks that night. The process server then gave the process to Mr. Ushery, filled out an affidavit of service, ostensibly saying that substitute service was complete. And that was the first, and I think really the primary method of service upon which the court relied. There was also reference to a mailing of service that occurred about 10 days later on April 10th, 2023, where my colleague placed a copy of the summons and complaint in the mail, registered mail, and sent it to the New Jersey address. And under New Jersey's service rules, service by mail is available. And what that requires is placing process in the mail, certified mail and ordinary mail contemporaneously, and sending it to the address. I think that was one of the things that the court also based its ruling on. Now,
let me
Yes,
stop
Your
you
Honor.
there for a minute. I understand. I don't disagree with the thing you've said so far. My question is this: how do we know the trial court relied on that?
Excuse me, Your Honor. I believe there are explicit references to it in the May 1st, 2025 order.
Does it say that in the order?
I believe the order says that, I believe Judge Hurd said that Mr. Melton was properly served under Tennessee and New Jersey rules, and there was a reference to the March 29th substitute service on Mr. Ushery, as well as the April 10th, 2023 mailing.
It's your understanding and belief that the trial court did specify which service of process it relied upon?
I believe that Judge Hurd expressly incorporated both of those methods to find that service had properly been effectuated. That's correct.
And that would be in which order?
I believe that is the May 1st, 2025 order.
Not the motion, not the hearing on the motion to reconsider, but the original motion? The original order, I'm sorry?
Well, the motion to set aside was actually heard twice. It was heard once in December of 2024 and once in, I believe, April of 2025.
But there was no order.
There was no
on the
order
first
arising.
hearing, correct?
That's correct, Your Honor. So there's only one order on the motion to set aside, and that is the May 1st, 2025 order. Was it discussed in the second hearing that occurred in April? I believe it was, but it actually appears in the order, Your Honor.
Okay. Go ahead.
Yes, Your Honor. And so Mr. Melton's contention is that this substitute service of process on his uncle, Mr. Ushery, it certainly didn't comply with Tennessee Rule of Civil Procedure in terms of substitute service, because there's a requirement that the defendant must be evading service before that substitute service can be effected. And frankly, I think to the appellee's credit, they've sort of backed away at the appellate level from arguing that substitute service was proper under Tennessee's rules. They seem to really be traveling under New Jersey's rules. And of course, Judge Hurd said she found that it complied with New Jersey's rule. But the substitute service in New Jersey requires service upon a competent member of the household, 14 years of age or older, then residing therein. And there's really no debate that Mr. Ushery was competent or that he was over the age of 14. The crux of it comes down to what does residing mean in terms of service. The appellee has taken the position that because Mr. Ushery was visiting there, because he had visited there before, residing is an expansive term. It's sort of all-encompassing. But I think New Jersey law is very clear that residing in language is not as broad as the appellee would like to read it here. And there's plenty of cases where, for instance, there's a case where an adult son was staying with his parents over the course of the Christmas holidays, was served with process for his parents, and the New Jersey appellate court said, that's not good enough. He might be a family member, and he might be staying there for a while, but that is not good substitute service because he is not residing in the property. And Your Honor, I see that my time has expired.
Thank you. You've got your rebuttal time.
Good morning, Judge McGee, Judge Stafford, Judge Smith, Clay Culpepper here from Evans Petrie on behalf of the appellee, Dr. Scott Werner, and the original plaintiff in this case, Dr. Stanley Werner, who is now deceased. The way Mr. Greer ended his argument is exactly where I wanted to pick up, which is, first of all, Mr. Melton was properly served. The trial court found that he was properly served, and he was properly served through his uncle, Steve Ushery, in New Jersey. And the question is, under the New Jersey rule for service of process, what does this phrase, then residing, mean? Well, there's a case that I want to draw the court's attention to. It is attached to my brief out of New Jersey. It's Bank of New York versus Tross. And in this case, from the New Jersey Court of Appeals in 2011, it goes into granular detail as to what this then residing means. It provides a complete analysis on this very issue. And what it says is that New Jersey courts apply a flexible standard for household member status that does not require permanent residence, temporary presence with a sufficient nexus to ensure actual notice satisfies this then residing requirement. Even if the uncle was visiting rather than permanently residing, his relationship to the defendant and presence at the residence when the service occurred would establish him as a household member for service of process. In fact, in this case that I cite, Bank of New York, this was a foreclosure action, and the defendant was not at her home. She was staying purportedly with an ill mother. Her brother is the one who happened to be visiting and accepted service process. Now, interestingly, the brother denied ever receiving service of process. But the court in that case, first of all, held that the process server's affidavit is to be presumed correct, and that the affidavit or testimony of the one receiving process or the defendant is not enough to overcome that presumption. But in this case, not only did the brother state that he didn't receive process, He stated, hey, I don't live here. I was only visiting. I live somewhere else. Well, that sounds awfully familiar to what we have in this case. In analyzing the then residing and applying the law to those facts, the court, as I said, gave deference to the process server's affidavit. They stated that regarding service and whether, in this case, a default judgment is void, there must be a substantial deviation from the service of process rules casting reasonable doubt on proper service. The Court of Appeals held that substituted service in that case was indeed proper under the then residing analysis, and that the test for who qualifies as a household member is flexible to accommodate non-conventional family arrangements. The member of the household formulation was intended to be more expansive than the previous member of the family standard in the older rule. The plain language of then residing implies that the recipient of service need not be a permanent resident of the household, need only be residing there when service is made. And the key is whether the person present in the household is sufficiently connected to the defendant such that the actual notice is reasonably assured. A person can be a resident of more than one household. And so there's this nexus regarding then residing that they go into. There must be a nexus between the individual, that is the uncle in our case, and the defendant that establishes some reasonable assurance that notice would reach the defendant. Then there's a whole list of examples that the court goes through in other cases that it cites. A periodic overnight guest qualifies as then residing. A mother-in-law staying at a defendant's home while recuperating qualifies. Service on a mother-in-law even though she did not live there in a separate case qualified as then residing. Service on an adult child staying overnight alone in a defendant's residence qualified as then residing. The trial court in this case held that according to the process server's affidavit, Mr. Ushry, who's the admitted uncle of the defendant, was properly served and that service was effective as to the defendant in this case. Now, in so determining, Mr. Ushry submitted an affidavit or a declaration to the court talking about all sorts of stuff. Well, that affidavit was later determined to be fraudulent, hence the rehearing on the Rule 60 motion. In the trial court, Judge Hurd found or determined that Steve Ushry, Mr. Melton's uncle, his credibility was, or he lacked any credibility whatsoever. And so I think the fact that he was the uncle, that he was admittedly at the residence, that he admitted to receiving the service of process, that he submitted a false declaration, and that not only that, he was also present, admittedly, at the time of the dog attack in Tennessee. So clearly, this guy has a strong connection to his nephew, the defendant in this case.
Well, he was the one who also was cited to environmental court, was he not?
That's correct. That is correct, Your Honor. And let me point to the declaration of Steve Ushry. This is in the trial record 399, trial record 252. Paragraph 7, Ushry admits that he periodically visited Melton. Paragraph 8, he admitted that he was at Melton's home the day of the dog attack. Paragraph 28, he admitted that he periodically visited Melton while in New Jersey. 29, he admitted that he was at Melton's home on the day of service. And 32, he admitted to receiving service. Now you look to Melton's declaration, paragraph 17. Melton says he relies heavily on others to assist him with matters, including reviewing and receiving mail. Paragraph 19, he admits that Steve Ushry is his uncle and was at his home in New Jersey. This case is the case that was determined, the Bank of New York case in New Jersey, that again goes through this full analysis on this very topic, is not even as strong as the case we have here, where we have an uncle who's clearly spends a fair amount of time with his nephew, the defendant in this case, admitted to receiving service, and for whatever reason, we still don't know, he just never gave it to Melton, or Melton didn't do anything with it. I don't know. We still don't know the answer to that question.
Let me ask you a question about the numerous attempts at service of process. Are you relying only on the New Jersey service, or are you relying upon other attempted service on the defendant as well, here in Tennessee, or by constructive service? I just want to make sure we're analyzing this correctly.
That's a good question, Your Honor. I am certainly, I think the overwhelmingly strong argument for service is the personal service affected on Mr. Melton's uncle, Steve Ushery. Secondarily,
In New Jersey?
in New Jersey, pursuant to the New Jersey rules of civil procedure on process. Secondarily, service of process was also affected under the New Jersey rules, which clearly we didn't even get into this, but Tennessee allows service of process under its rules. It also allows service of process under the rules of the state in which service is affected. So I'm also relying on service of process via certified mail and ordinary mail, the conjunction of those two. And there's an affidavit that went along with my motion to serve via publication that lists out my various and numerous attempts to get Mr. Melton served. And then we've got the actual service. And then the service by mail was really a follow-up just to ensure. And I think it's important for the court to note here, and it's all throughout the record, throughout this entire case, prior to service, service, and beyond service, every notice, every pleading, every discovery request, every notice of hearing, everything was always sent via certified mail or FedEx to Mr. Melton's residence, to the practice facility for the Philadelphia 76ers, and to the front office for the Philadelphia 76ers. There has never been any attempt to pull the wool over Mr. Melton's eyes, to get him to hopefully not see what's going on here. Every attempt was made, and I think the trial court made that clear, not with respect. Let me separate service from actual notice, because the actual notice then comes into play, as I shift gears here, to the judgment. And in talking about the judgment.
Well, before you get into that, let me take that a different way for just a moment. As far as the actual notice of the litigation, did the trial court ever analyze that under a Rule 60 analysis as far as the timeliness of the Rule 60 motion? Did the trial court rely upon the notice that the defendant purportedly had, as per your argument, about the ongoing litigation?
Yes, Your Honor. And what the court determined was that not only was Mr. Melton's response untimely, but she ruled that it was willful. And as the Court of Appeals has held, they give great deference to a trial court's determination of willfulness. And in this particular case, what the trial court examined was the fact that after the judgment was obtained and after the judgment was sent to Mr. Melton in October 31, starting in December, we have a month before that becomes final, so we're now in the 1st of December, and as soon as December hits, we start issuing garnishments and levies against Mr. Melton. And that occurs for 7 months. Over 15 separate garnishments and levies were issued, were collected against his employer, were submitted, that those payments were made to the trial court, held for 30 days, and then released to the plaintiff. Over 15 times. 9 months since the date of the judgment. And so the trial court held that that was unreasonable and took it a step further and stated that that conduct was willful. And yes, that was part of her analysis and reasoning in denying the Rule 60 motion. As it relates to the amount of damages, I see I have less than 2 minutes left. I think it's important to note that, as I stated in my brief, the issue as it relates to damages is a Rule 59 issue at best. In fact, if you look back over 100 years of case law dealing with Rule 60, if you look at the almost 400 notes of decisions that go with Rule 60, you know how many cases you'll find where Rule 60 was granted or upheld over the size of the judgment or over an excessive judgment, over addendum? Not one. But what you will find is that under Rule 59, such arguments have been successfully held. And as we all know, and as set forth in my brief, Rule 59 has a strict 30-day time limit that cannot be expanded. If Mr. Melton was served in this case, he had an opportunity at that point to defend himself. When he received the request for admissions, the motion for summary judgment, the affidavits relating to the judgment amount that was obtained, he had a chance to dispute those. He didn't. Those admissions were deemed admitted.
Let me ask you a question about those. And this also goes to your damages amount. The trial court, it's my understanding, based the amount of damages on the request for admission that the court deemed admitted.
Correct, Your Honor.
Those requests for admission were sent to the defendant at what point?
Those requests for admissions were sent, I believe it was around the April-May timeframe, and they were sent via mail and via FedEx and signed for by a Melton. Of course, we don't have a picture of, but a Melton signed for them.
Was that before or after the service in New Jersey, which you rely on and argue was good service?
After.
All right, thank you.
And so those are Rule 59 arguments. There's not a single historical or appellate decision relating to the size of the judgment under a Rule 60 analysis. Mr. Melton had his chance, had multiple chances to address that on the merits through summary judgment, through Rule 59, or through a direct appeal of the judgment. And he waived all of those through his willful and unreasonable delay.
Thank you. You've used your time.
Thank you.
Thank you. I'm curious as to your Rule 60 basis. Which specific part of Rule 60 are you relying on to?
3 parts, Your Honor. Okay. Rule 60.02, Subpart 1, Subpart 2, excuse me. Make sure I close this right. 1, 3, and 5, I believe, if memory serves. We've got the mistake, inadvertence, excusable neglect. We've got the fraud and or misrepresentation subpart, and then we've got the any other relief, the Section 5 catch-all, Your Honor. Your Honor, I just want to, and to go back and answer one of Your Honor's questions to me in my initial argument, you asked me about whether the reasonableness of the filing of the motion was something that was put at issue directly in the statement of the issues. And I waffled on that question, and I'll confess to Your Honor, I just didn't remember. It is. It's issue number 1 in our statement of issues. It's in our brief. So that is covered in the statement of the issues. I also want to briefly touch on the case that Mr. Culpepper seems to be primarily relying on out of New Jersey. That's the Tross case. The Tross case is an outlier. There is that case, but there is a large body of cases that say essentially something very, very different. And I think the Tross case was a little bit unique because the brother that was served in that case, there was no evidence, there was no representation, there was no contention that he actually resided anywhere else. In other words, the sister's home where he was served That was the only place that he ever admitted to living in. And I think that was one of the determinative factors, which is something different than what we have here. Mr. Usury's driver's license is in the record. He's obviously made the declaration. He's a resident of the state of California. So I think Tross, an unreported decision, I think that's an outlier. It stands in contrast to probably half a dozen other cases that we've cited in our brief. I also briefly want to touch on Mr. Usury's declaration. It was not a false affidavit. There was I think one line in the original declaration that was not correct. Now, we filed that original declaration in July of 2024 when we filed the motion. The motion, Dr. Werner responded to our motion in August of 2024. Didn't contest any of the factual issues in there. We then have a hearing a few months later in December. None of this comes up. This issue about this one thing in the declaration didn't come up until after Judge Hurd had already originally granted the motion. It was corrected immediately. Mr. Culpepper reached out to us, said, I don't think this is correct. We did an investigation. It wasn't correct. My obligation was to make sure that I'm operating in full candor with the court. We filed a corrected declaration. So it's not that everything Mr. Usury says can't be relied upon. There was a mistake. It happened. We own that, but it was corrected.
Well, are we going to find where Judge Hurd made these findings that he wasn't credible?
I believe she actually uses that terminology in the order. That's correct, Your Honor. Now, the mailing that we talked a little bit about, that April 10th, 2023 mailing, upon which Judge Hurd relied and the plaintiff seems to rely, mailing is not one of the things that you can go to first. You must first try personal delivery to the defendant, then the substitute service that we've been talking about under the New Jersey rules, and then you can go to the mailing. In fact, one of the prerequisites for the option to mail by service is to make good faith attempts at personal service before doing it and to file an affidavit attesting to those good faith service attempts. That never happened in this case. The affidavit that Mr. Culpepper is referring to, I believe, was actually filed 6 months before the April 10th, 2023 letter was ever sent. It talks about some of the mailings to the 76ers and perhaps service by publication, things like that.
Are we talking about Tennessee service or the service in New Jersey?
I'm talking about the validity of the service in New Jersey. Okay. The idea that there has to be this affidavit that attests to the good faith personal service attempts before turning to service by mail. The affidavit predates all of that. Your Honor, and I see that my time has expired. I just wanted to briefly touch on the garnishments. The garnishments were issued over a period, as Mr. Culpepper said, about December of 2023 to July of 2024. I think the first time money was ever removed from Mr. Melton's account was either the last week of March 2024 or the first week of April 2024. Mr. Melton reached out, retained our firm, and we filed the motion in July. There was not some sort of huge delay. When he noticed the money was missing, he retained counsel, we filed the motion. I see my time has expired, Your Honor. Thank you. Appreciate your time this morning.
Thank you, counsel. We will take this matter under advisement, and we will attempt to get you an opinion at the earliest possible time. Obviously, we'll get the opinion to Professor Vescovo so she can share it with the students.